Wow. I mean, that's a pretty intense statement, right? But let's be honest. If you've ever stared at a 30-page moot problem feeling completely overwhelmed, you know there's some truth to it. The case isn't just lost in front of the judges. Nope. It's often lost right at the very beginning, before you've even written a single word.
So let's get right into it. Today we're going to break down one of the most critical skills in all of mooting. Seriously, this is the thing that separates the people who win from everyone else. And it's all about mastering the moot problem. But I'm not just talking about, reading the words. We're talking about how to read like a lawyer who's already plotting out their path to victory.
All right, so what's the biggest trap in mooting? It's kind of a hidden one. It's this fundamental mistake in how you approach the problem right from the get-go. It's that first instinct that feels totally right, but in reality, it's setting you on a one-way track to a weak memorial and, you guessed it, a totally fumbled oral round. And here's what it boils down to. This one single flawed assumption that pretty much every single law student makes. We think that if we read the words, maybe highlight a few key words, and get the general story, that we've actually understood the problem. But that simple little equation, reading equals understanding, that is the exact spot where your entire case can start to fall apart. So starting with that flawed assumption, you end up making a bunch of predictable, let's call them panic moves and pitfalls. These are the classic traps that can absolutely cost you the competition before you've even drafted a single argument. But here's the good news, and it's really good news, they are completely avoidable. So, what do these mistakes actually look like in practice? Well, first off, you read the whole thing like it's a novel, looking for a plot instead of looking for legal triggers. Then comes that classic panic move. You jump straight into legal research. Huge mistake. You probably skim over the procedural history. Big error. You barely even glance at the prayer for relief, which, by the way, is literally the entire point of the exercise. And of course, you miss those key dates that could make or break your entire case.
What this really shows is a massive difference in mindset. You've got the story reader on one side, just passively following the plot, but then you have the legal analyst. This person is an active participant. For every single fact, they're asking, okay, why is this detail here? What legal issue could this possibly trigger? It is a completely different and way more powerful way of engaging with the problem.
And this right here leads to probably the most common mistake of them all. You see a keyword, right? Maybe it's Article 19 or something, and bam, you're off to the races. You've got a dozen tabs open in Manupatra or SCC Online. But here's the problem. Without the full context of the case, all that research is just shallow. It's unfocused, and you end up wasting hours and hours chasing down case law that is totally irrelevant. Okay, so this brings us to the absolute core of it all. The huge critical difference between just reading the problem and truly, deeply understanding it. And I'm telling you, getting this distinction, that is the aha moment that will completely change how you prepare for every moot from now on.
So let's just pause on that for a second. I mean, think about it. We've all said it, right? Oh, I've read the problem 3 times. But what does that actually mean? What's the real, tangible difference between just reading it and really, truly understanding it?
Here it is. Reading is passive. You're just letting the words wash over you, maybe highlighting a few things. It feels comfortable. But understanding, that's an active process. You have to become a detective. You're questioning every single line, connecting the dots between facts and legal issues, and you start to see this hidden strategic map that's laid out right there in the problem.
And you know what? This is exactly why so many of us get stuck in that passive reading phase. Because it feels like work. It feels productive, like you're making progress, but it's a total illusion. It's a false sense of security that's actually super shallow, and it leaves you completely unprepared for the tough, deep questions that judges are absolutely going to ask you.
Okay, so the big question is, how do we get from that passive reading to active understanding? Well, what we need is a toolkit, a system, a repeatable method for breaking this whole thing down, for taking it apart, piece by piece, just like a seasoned lawyer dissects a case file.
First things first, you have to completely reframe how you think about it. A moot problem is not a story that you just read from page 1 to the end. No, it is a legal puzzle. And just like any puzzle, it's made up of a bunch of different pieces. Your job is to identify all those pieces and then figure out how they fit together to create the full picture.
The absolute key here is to use a system. So let's break it down into a really simple 4-stage framework. Okay, stage 1, get your bearings. Just who are the parties, what's the basic context? Stage 2, map the journey. What's the procedural history? What did the lower courts already decide? Stage 3, find the conflict. What are the key facts, the main arguments, the legal issues at the heart of it all? And finally, stage 4, know the goal. What exactly is your side asking the court to do?
All right, theory's great and all, but let's make this super practical. We're going to take a sample moot problem and actually apply this dissection method, and you'll see just how fast it can bring a complicated case into sharp focus.
Okay, just look at this. In just a few minutes of dissecting, we have pulled out the entire strategic core of this case. The cause of action? A violation of freedom of speech, Article 19. The procedural history? The High Court already dismissed it, calling it a reasonable restriction. Aha, but here's the key fact, the game changer. The order was issued without any prior notice or hearing. And the relief sought? This is huge. They're not just asking to quash the order. They want to declare the entire Section 7 unconstitutional. Do you see how this instantly tells you exactly where to focus your research? It's like a roadmap.
So now, let's bring this all back to the final goal. Because this isn't just some boring academic exercise, right? This whole process of smart reading and dissection, this is the direct pipeline to strong, confident, and winning advocacy.
And this chart, wow, this really puts it all into perspective. Just look at where the real work of winning a moot actually happens. A massive 50%, half of the entire effort, is in this initial stage of smart reading and dissection. That is the foundation. Everything else, your research, your memorial, your oral arguments, it's all built on top of that. And if that foundation is weak, the whole thing is just going to collapse.
So how do you know? How do you know when you've finally crossed over from just reading to truly understanding? Well, here's a little checklist for you. You can list the material facts from memory. You can explain the entire procedural journey of the case, no problem. You know the precise relief being asked for. You can already see which facts are your weapons and which facts you're going to have to defend against. And because of all that, your research becomes a laser-focused surgical strike, not just some random hopeful search.
So, remember this. Before you write a single word of your memorial, before you look up even one case, just keep this in your head. Your absolute strongest argument, it always starts with your smartest reading.
And hey, just so you know, this entire explainer was based on a really fantastic guide called How to Read a Moot Problem. It's by Kirthi Dubey, who's the founder of Law-Spectus. So a huge shout out and credit to her for breaking all of this down so clearly for everyone.
All right, we really hope that helps you get ready to absolutely crush your next moot. If you found this useful, you know the drill. Don't forget to like, share, and subscribe for more explainers just like this one. We'll see you in the next one.